Yes, colonist.
From the witness, number 1.
US supports. Oh, yes.
My lord,
I'm
today
filing
we
the
have
report, my lord, with the photographs.
I've received
You have
a
seen the
copy of
report,
the
Mr. Shanmugha?
photographs, my lord. My lord, we'll require some more time to address to all the damaged portions, my lord, and get it repaired, my lord.
No, no. How much time? You have to give us a deadline. It cannot be open-ended. It cannot be open-ended. It's going on for the last 3 years.
My lord, major strengthening has already been taken up and done, my lord. But
Strengthening is one issue.
whatever has been pointed out and whatever has now come up, my lord, this will be looked into immediately. I am praying for if the matter can come up after vacation, my lord. In the meantime, we'll file a completion report.
But in the meantime, we are going. We will travel.
Yes, my lord is always at my lord. What I would pray is that my lord, if my lord goes after it is after granting us time, my lord, I am sure my lord will.
We'll go in between.
Now in this position, my lord, it is admittedly, my lord, the road is in a, it needs attention, my lord. So I was praying if my lord will kindly grant us some more time, and we may be able to address the entire stretch, my lord. And it will be a pride of our state also, I am sure of it.
Stay down.
Madam, kindly come to the last affidavit
The
which has been
report
filed.
filed by the amicus is taken on record. Full stop. The report reveals that Yes.
From the witness, item number 1.
Yes.
May it please your lordships. Lordships, I appear on behalf of the petitioner. Lordships, this is a matter wherein the petitioner had applied for a post of constable against an advertisement released in 2010. In 2011, he was selected, and 3 years after his service, he was told that there was some discrepancy in his documents, and therefore a departmental inquiry will be held against him. Thereafter, your lordship, he is reinstated in service in 2016, and after 10 years of service, on the basis of a legal opinion, the petitioner has been discharged from service without issuance of any show cause notice as far as that termination order is concerned. Now, your lordship, the petitioner's grounds are firstly substantive on merits and secondly procedural. The procedural ground is that there was no show cause notice mentioned, and there's one judgment, your lordship, that the petitioner will rely on, which is to the effect that in such situations where, as alleged by the respondents, the appointment was void ab initio, the requirement of issuance of a show cause notice cannot be dispensed with. Now, your lordship, for the substantive argument, initially when the departmental inquiry was held, the charge against the petitioner was that he had misled the selecting authority by representing himself as a selected candidate, when in fact the person who was selected was someone else. Now, your lordship, to understand what exactly happened during the time when this alleged representation was made, it is important to see what happened after the result was declared for the selection process. So, your lordship, the selection process happened in 2011. Soon after February and March, the petitioner appeared for a written test, and thereafter the result was declared in November of 2011. In the result list, your lordship, the petitioner's name is Dhananjay Hajong, whereas in the result, the name Dhananjay Hajong was written, and the only difference was that instead of the letters A, instead of the letter O, the letter O was instead mentioned. Instead of letter A, letter O. Now, your lordship, the petitioner was under the bona fide belief that this was a typographical mistake, and on this basis, the petitioner approached the concerned authority saying that no call letter has been issued to me. However, I believe that this may be a typographical error, and for that reason, I request you to confirm if I am the selected candidate or not. When the petitioner highlighted this to the selecting authority, the petitioner was told to go ahead for documents verification. The petitioner took his correct documents, which mentioned his correct name, his correct father's name, his correct address. He submitted these documents. These documents exchanged the hands of 2 to 3 people, and thereafter the petitioner was told to go to the concerned commandant. When the petitioner approached the concerned commandant, he was handed a provisional appointment letter, and in that letter, the name of the petitioner was again mentioned incorrectly, to the extent that instead of the letter A, the letter O was mentioned. So the petitioner's name is Dhananjay Hajong, and the name which was mentioned in the provisional appointment was Dhananjay Hajong. So instead of the letter O, letter A was mentioned. Your lordship, if the petitioner wanted to mislead the authorities, there was no reason for him to highlight this error at this stage. He could have easily taken the provisional appointment letter and gone to the further selection process, the medical test and the physical test. However, your lordship, he specifically highlighted this error, and the commandant in response stated that this was a small error and it will be rectified in future. It is also pertinent to note, your lordship, that in this provisional appointment letter, the father's name of the selected appointee was in fact the name of the petitioner's father. Therefore, on the basis of this provisional appointment letter, there was no reason for the petitioner to believe that he was not the selected candidate. If anyone had made a representation throughout this transaction, your lordship, It was the selecting authority which reiterated more than once that the petitioner is in fact the selected candidate, and therefore he was told to go ahead for the rest of the procedure. Your Lordship, thereafter, the petitioner was in service for 3 years. There was no misconduct, no disciplinary. It was an unblemished, flawless service that he had rendered. And even after his suspension order was revoked in 2016, between the period of 2016 and 2022, when he was finally discharged, he was involved in counterinsurgency measures in Garo Hills, and he had been used as a indispensable asset by the Meghalaya police. After that, Your Lordship, without the issuance of any show cause notice, the petitioner was told that he is discharged from service. Now, Your Lordship, there are multiple judgments of the Honorable Supreme Court of India and also the Andhra Pradesh High Court, which are to the effect that in such situations where the selecting authority has committed a mistake, and for that reason there was an irregular appointment.
What is your answer to paragraph 6 of the judgment? Read paragraph 6 of the judgment.
May I read it, Your Lordship? On a bare perusal of the materials as placed, firstly it is noted that the writ petitioner had been allowed adequate opportunity to defend himself and to produce materials in his defense. It is also noted that the documents relied upon by the respondents were inspected, and in fact the writ petitioner had filed 2 show causes on the charges framed against him. From the materials as placed and from the affidavit, it can clearly be seen that in the selection process, the selected candidate's roll number was 8584, whereas the petitioner's roll number was 33003. This court has also ascertained the same from an annexure appended to the affidavit, wherein the relevant name appears at so-and-so pages of the affidavit, showing the name of the selected candidate, Sri Dhananjay Hajong, and not the name of the petitioner, which is Dhananjay Hajong.
So, what is the answer to this paragraph?
Your Lordship,
Has it gone? Where is factual inaccuracy in this order?
Your Lordship, it is.
If you have a roll number, and if you use the roll number of someone else, and 8584 is a roll number for the candidate who has been ultimately chosen, then it's a prima facie case of impersonation.
However, Your Lordship, the petitioner.
Not however. You have to answer this question.
Your Lordship, the petitioner had unfortunately lost his admit card during the period from the selection test to the declaration of result. Therefore, he had no means to verify his candidature against the roll number. In such a fact scenario, Your Lordship, the next step that
has he lodged any FIR on the loss of admit card? Any general diary to the police station that he has lost the admit card? And when he lodged that general diary?
Your Lordship, he did not file an FIR.
Sorry, thank you. Get out.
Your Lordship, if I may submit just one thing. Your Lordship, in this, the admit card itself has not been proved as per any departmental inquiry. And Your Lordship, however,
Not required. This is your
paragraph
document.
6.
Get down. This appeal is arising out of a judgment order
Please, Your Lordship. Lordship, this is a case of ostracization, my lord. So what has happened in this matter, my lord, the appellants were specifically targeted by the villagers, my lord.
Just.
Yes, my lord.
Yes, so how you are aggrieved by this order?
My lord, because what has happened in this matter, my lord, the villagers were specifically targeted, my lord.
Sorry?
The villagers have specifically targeted the appellants and 14 other families, my lord, because they did not participate in the vandalism and cruelty meted out to one of the villagers, my lord. Here, being aggrieved by the ostracism, my lord, they have lodged an FIR before the officer in charge of Kharkutta PS, my lord, on 6 July 2025, my lord.
Charge sheet has been filed.
That has been filed in some other case, my lord.
No. You have made a complaint.
Yes.
On the basis of the complaint, a charge sheet filed.
No. Action has not been taken. That is why before this honorable court, my lord.
Yes, who is appearing for the state.
My lord, I'm appearing for the state lordship. My lord, just a brief background about the case. What is before this honorable court today is the third FIR lordship. Actually, the complainant here and the petitioner, they are a group of people, and so far till July, 3 FIRs have been filed lordship. The first and second FIR have been charge sheeted, and with regard to the third FIR, there was a counter FIR from the other side. So the IO prepared a preliminary conducted a preliminary inquiry, lordship, and accordingly the same was sent to the court of the magistrate, my lord, to maintain peace and law and order. Lordship, after the order of the learned single judge was passed, they approached the SP, my lord, and he said this is a non-cognizable offence. A non-FIR has been filed before the court, so at the most what can be done is to settle the matter. But they refused. They said that they will contact the first complainant of the first FIR, lordship.
No, see, there are 3 FIRs, correct?
3 FIRs, my lord.
2 resulted in a charge sheet.
Charge sheet, lordship.
2 complaints are by them.
Lordship. First and second.
No. 2 complaints by some other villagers, my lord.
First and second is the same group of people, my lord.
No. That is false.
It's
No,
the same group.
just wait.
Lordship.
The first 2 FIRs which you say is
Lordship.
not lodged by them,
No.
by some other person.
Yes.
Some other person.
Maybe belonging to the same community
Same
Yes.
group, lordship.
or group, same group.
Yes.
So, according to you,
Charge sheet has been filed.
the complainants belong to the same group to which the present writ petitioner belong.
Lordship.
That's your case?
Lordship.
So, charge sheet, so there must be a substance in the FIR, otherwise charge sheet would not have been filed. So,
Lordship.
charge sheet was filed.
Lordship.
So, in respect of the third,
Lordship.
there is a claim and a counter claim.
Counter FIR, my lord.
Counter FIR.
Lordship.
So, there he has conducted the inquiry
Lordship.
and filed a report before the
SP.
Before the
The SP and before the SP saying that the PE has been conducted, lordship, and accordingly it was sent to the court of the magistrate because it's a non-FIR matter.
no, but it is, we call it FRT. FRT.
Yes.
FRT filed.
Yes.
So what is the result of the FRT? Did the magistrate accept it?
My lord, it's there, my lord. It's on the last page.
The final report was filed saying that there is no offence or what?
My lord, both the counter FIRs have been sent for execution of maintaining peace and tranquility, my lord. So the orders from the magistrate are awaited. My lord, it's at the last page, my lord.
Yes.
Page 39.
You're under page 38.
39, my lord, last page.
39.
So this is with regard to the The present FIR, my lord, this is what has transpired in the
Just,
other,
just give a moment, please.
my lord.
So it's a two group of villagers.
My lord.
BNSS. BNSS is not there. No, but there is no FITT. There is a third complaint. So there are two already FIRs
Lordship.
that are culminated in a charge sheet.
Yes.
The first two culminated into a
Yes.
charge sheet, Lordship. Yes.
Same.
Exactly. Lordship.
So third one is not yet. There is no. It's in the stage of investigation.
No, my lord. Investigation, that is the PE, was conducted within 14 days, my lord. At the same time of the third FIR, there was a counter FIR. From
So
both
what is the
sides.
outcome of that?
My lord, the same is pending orders from the magistrate, Lordship, because they have both been sent to the magistrate as non-FIRs, Lordship.
As
Non-FIRs.
so they don't disclose any offense.
My lord, no offense has been
No
disclosed,
action has been
my lord,
taken, my lord.
because
That is why.
at page 34 is the FIR, Lordship. Page 34 is the FIR.
No, on all complaints may not result in the charge sheet.
Lordship.
That's fine.
Charge sheet, Lordship.
Not necessarily that. So far as the counter FIR is concerned,
Lordship.
he said that I find merit in it as per my inquiry and views as mentioned. Page 37.
Lordship.
He referred to the two letter FIRs, correct?
Lordship.
So one FIR, he said that it does not disclose any offence. I don't find a reason.
Lordship.
But so as second FIR is concerned, on 17 July 2025, he said that I find that's what he said.
Lordship.
So both did not result in FRT.
My lord. The second FIR is at, the counter FIR is at page 38, Lordship.
I go by whatever you have given to me.
Lordship. And views as mentioned, Lordship. And views as mentioned.
I find merit in it.
Yes.
Regarding the above noted authority, I find merit in it as per my inquiry and views as mentioned.
And views as mentioned, my lord. So it's the same result.
I find merit. If you find merit, then you
Lordship.
can't have a same views mentioned.
English is a second language, my lord, but my lord, views as mentioned, my lord.
You
If
say
I may be
views-
permitted to speak, my lord.
Views as mentioned, just a minute. You say views as mentioned,
My lord.
then I find merit doesn't make any sense. If I say I find merit in the other one,
My lord.
and then views as mentioned, they're contradicting.
The contradictory, but the latter part says views as mentioned, my lord.
Yes, what do you want to say?
Yes, here, my lord, the police, they're actually supporting the other villages, my lord, the other group. That is this reason why, my lord, we have to approach this honorable court. In fact, what has happened, my lord, even after the passing of this judgment, the appellants, they approached the one-stop center, my lord, to collect the statement given by the private respondents that they have indefinitely ostracized the appellants and the 14 other families, my lord. Thereafter, the one-stop center also, they took them directly to the SP, wherein the SP threatened them, my lord, that they'll put behind bars if they still continue with this matter, my lord.
That's absolutely false, my lord.
That-
I'll give a reply to that.
Lordship, that is the reason why we approached the single judge also, my lord, on the allegation that the police themselves, they are supporting the villages. And in fact, in one of the annexures, my lord, I have enclosed a photocopy, wherein two police personnel, they went to the victim of one of the ostracization, my lord, with a pen and a paper, my lord, to collect their signatures. That late at night, my lord. That is why we made a categorical statement before the single judge that the police themselves, they are supporting the other villages, my lord, other group.
That's absolutely false,
That-
my lord. When the first and the second
And
FIRs
my lord,
were filed, my lord, what
and
the
during
state
the
has done from
proceeding
the
also, my
police,
lord, they have
they
enclosed
asked
the
complainants to
the
stay
charge
at
sheet of the
circuit
other
house,
case, my
which
lord.
they refused, lordship.
And on the basis of that other charge sheet, my lord, the matter was disposed of, directing us to go and approach the SP, my lord. When we have already went to the SP with a complaint, with our grievance, my lord, the SP did not do anything, my lord. After that only we approached the honorable court, my lord. And going back to the same authority will not serve any purpose, my lord.
In
See, in fact,
protection
the
was
action,
offered to them,
inaction
which
of
they
the-
declined,
the-
my lord.
because of
They
the inaction of the
actually
police,
declined
my
the
lord.
protection that was offered to them by the state, lordship.
That
It's
is
on
in some
record,
other case. That is in
it's
some
on
other case,
record,
not in
lordship.
this case,
It's
my
the
lord.
same parties involved, my lord.
No, my lord. They actually targeted one of the villages just because they were from an indigenous religion, my lord. And these people did not participate in the vandalism. Only because of that, they started targeting the other villages, my lord.
The records
That
will
is,
speak,
that
lordship.
the record says so, my lord, because the charge sheet has been filed by the police.
The records will speak for themselves.
We have no problem compromising, living peacefully there, my lord, in the village. But the only problem is that the police themselves, they are supporting these people, and because of that, they are emboldened, my lord. Had the police done some action, my lord, then there was no need of coming before this honorable court. There were nowhere else to go, my lord.
The case of the complainant, my lord, is that they want the matter charge sheeted. All FIRs cannot be charge sheeted, lordship.
I'm not saying that, my lord. At least I need the protection of the police, my lord. But the police themselves, they're supporting these villagers, my
And
lord.
they were offered the protection which they declined.
That is in some other case, my lord, not in this case. In fact, the police themselves, they're saying that we'll put you behind bars, my lord, if you still insist on pursuing with the matter. So where will the appellants and other villages go, my lord? If that be the case. If the police had taken any action, my lord, then there was no need of coming before this honorable court. Even the basic rights have been denied to them, my lord. They are not able to participate in the village activities also.
Disagree, lordship.
See that.
Before the executive magistrate, lordship. Because it's a non-FIR, lordship. So for peace and tranquility, it's always forwarded to the executive magistrate.
Lordship. You already approached, my lord. Prior to this, my lord, we already approached the superintendent of police, my lord. Thereafter, after this judgment was passed, my lord, we went to one-stop center to get the statement recorded by them, my lord, from the private respondents, my lord. They did not give us that statement. Instead, they took us to the SP, my lord, after this judgment was delivered. So the SP told us that you either withdraw this matter or you settle it among yourself, or else I'll put you behind bars, my lord. Yes, my lord, we have a written complaint, my lord. It's page 46, my lord. Nothing, my lord. No action was taken thereafter.
No, my lord, this is 18th of July, lordship. This is not after the order.
Lordship. We are before
My
this
lord?
honorable because our fundamental rights have been infringed, my lord. Yes. 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 No, after the judgment, we have not filed a
No
written
complaint
complaint.
was made, lordship.
No, that is why, my lord, my grievance is that we have already approached the SP. SP has not taken any action, my lord. Again, going back to this. Yes. Yes. Yes.
Make a complaint. If you are agreed by inaction on the part of the police, then you have a remedy. We can remedy available to you. But without making a complaint.
No, we already have submitted a written complaint, my lord.
No, after the order.
After the order, no, but prior to that, we have already submitted a written complaint, my lord. Yes, my lord. That was not, no, the SP has not taken any action, my lord. No, my lord. No, not at all, my lord. That is why we approached this honorable court. Thereafter that, the direction was given to us to again approach the SP, my lord. That is why being aggrieved by before this honorable court, my lord.
My lord, if I'm not mistaken, lordship, the IO, it was on the basis of this complaint that the IO was changed, lordship.
IO's change is not the thing. Stay down.
No, and any other action may
There
be-
has been claims and counterclaims between the parties, and it reveals that following 2 FIRs, charge sheets have been filed before the appropriate criminal court. However, the grievance